Welcome to Collective Draw Online classes. So in this section of the current affairs classes, we are going to discuss about the public awareness about the judicial decisions. So let's get into the analysis. So let's discuss what is the importance of this or the current relevance of these topics. So the legal provisions have a tendency to inhabit the Indian legal system after their legal death, and applying unconstitutional penal laws is examples of the Shreya Singhal and the section 66A in recent times. So because of this topic of public awareness about judicial decisions has appeared in the newspaper. So let's get into the detailed analysis. So this topic comes under your GS2 paper, Indian Constitution, historical underpinning, evolution, features, amendments, significant provisions, and the basic structure. So here let's analyze the issues or the concerns with respect to the lack of public awareness about the judicial decisions. Here, the Shreya Singhal versus Union of India case in 2015, the Supreme Court has struck down the section 66A of the IT Act, that is Information Technology Act 2000, as unconstitutional. And in October 2017, the police in Muzaffarnagar, Uttar Pradesh has arrested and detained an 18-year-old boy for allegedly committing a crime under section 66A for posting a comment in the social media. So which means that even though this section has been taken away from the legal statute or the legal provisions, the arrest and the detention under this scheme is going on because of lack of public awareness about this judicial decisions. And further, following this, media outlets have reported other instances where this section 66A has been invoked by police, all of which point to an obvious and serious concern. What is the point of that landmark decision if the police still jail person under the constitutional laws, which undermines this landmark judgment of the Supreme Court? And further, from this police station to the trial court and the way up to the High Court, this section 66A was still vague and throughout, or it is remaining in the legal system, and it is only struck down by when the case is reaching at this High Court. And this convicted person suffer the indignity of loss, arrest and detention for no reason other than their poverty, ignorance, inability to demand their rights, which means this is mostly targeting or is unfavorable to the poor and the downtrodden sections of the society, and they are being targeted with this provisions of the legal or the legislative system. Further, there is a pressing need to move from a system where communication about these judicial decisions is at the mercy of these initiatives by the scrupulous officers to a method not contingent to human error to the greatest possible extent. So here, the urgency cannot be overstated because it is impacting the lives of the poor and the downtrodden. Further, enforcing unconstitutional laws is a sheer wastage of the public money, and it is violation of the human rights also, and it is against the fundamental principles of the Constitution. And more importantly, under this basic flow within is addressed, certain persons will remain exposed to denial of their rights to life and personal liberty in the worst possible way imaginable. So in the earlier mentioned cases also, the person has been detained without any valid reason. Now let's analyze about the impact of absence of the communication about this judicial pronouncement. Then the Supreme Court in 1983 struck down the section 303 of the Indian Penal Code under the Mithu versus State of Punjab. And in 2012, that is years after this section 303 had been struck down, the Rajasthan High Court has intervened to save a person from being hanged. That is, the person has been taken to the verge of death sentence, being convicted under these offences. So the situation is that severe, or the gravity of the issue is so intense. So let's analyze why there is lack of communication regarding this judicial pronouncements. Here, the primary reason for poor enforcement of judicial decisions of unconstitutionality is the signal failure between the different branches of the government. And there are different branches in the government, including the judiciary, the legislative, and the executive. The executive will be mostly functioning under this legislative procedures, or the directions of the legislatures, or those laws which has been enacted by the legislator. So there is a gap between this judiciary and the executive is conducting this arrest and detention. So there is a lack of coordination between these organs of the government, and that is leading to failure of this lack of communication. So here the court can ask the state or other litigants for updates about the compliance with its order. While an example being the order in the mob lynching petitions, which is being recently given by the court. And while this monitoring function is one that the court can perform while litigation is in pending before the court, and it cannot do after it is finally decided upon the case. So once it finally decided upon the case, it has moved into the ambit of legislature. Now, apart from some high courts and the district judges for special district did issue circulars bringing important decisions to the notice of other members of the judiciary. So there is no formal system on information sharing in the hierarchy setup of the Indian judiciary. So this is also creating a lack of awareness in the judicial system. So how we can address this issue? So the way forward is that the probability of the decision taken at the highest echelon of the system being faithfully applied at the lowest rung greatly depends on how efficiently words get to the ground. So at present, even getting information across about the court decision is an area where the judiciary needs help, because unless the parliament amends a statute to remove the provisions declared unconstitutional, the provisions continue to remain in the statute book. This is why the section 66A and 303 are still part of both official versions of the statute published on Indian Code and the commercially published copies. So unless the legislatures make a law to remove this section, it still remains in the statutes, and that is being applied by the executive. Then, besides reading the statute, the government officials can consult notification and circular issued by relevant ministries while applying the laws. So in this regard, the ministries has to frequently or often has to release the circulars, and which includes the recent judicial pronouncements. Then these notifications are another official method to share information about judgments declaring a provision unconstitutional. So with this we come to the conclusion. So here you can get the detailed current affairs note from our website under the buddy scheme, and also you can get it from our Telegram channel. The video analysis will be uploaded in the YouTube, and you can subscribe to the YouTube channel, and the notes of the video classes are either available in the Telegram channel or